Good morning, this is your Kelso Report for Friday, November 16th, and I'm your host, Clark Kelso. Our cases today involve the proper scope of rebuttal in closing arguments, the application of the discovery rule to a claim against the government of wrongful disclosure of tax information, and the plaintiff's burden in an insurance bad faith case to rebut a properly supported motion for summary judgment. We start with closing arguments. Closing arguments are where counsel for the prosecution and defense have their best opportunity to sway the jury towards their client's position with zealous advocacy. But there are limits to how far counsel can go in closing arguments. It is, for example, improper to base closing arguments upon evidence not found in the record, although counsel are free to argue reasonable inferences from the record. And during closing argument, prosecutors have considerable leeway to strike hard blows based on the evidence and all reasonable inferences from the evidence. However, in the specific context of rebuttal summation, a prosecutor cannot use rebuttal to put forth new arguments. Rebuttal is restricted to responding to the points made by the defense counsel in closing argument. This rule keeps prosecutors from sandbagging and helps to ensure fair and balanced presentation of arguments to the jury. In United States v. Maloney, the defendant asked for a surrebuttal summation based on the contention that the prosecutor had introduced new arguments into the rebuttal summation. A majority of the Ninth Circuit panel held that the district court did not abuse its discretion in denying defense counsel's request for surrebuttal, because the prosecution statements in rebuttal summation addressed arguments made in defense counsel's closing argument and were based on permissible inferences from the record. A dissenting judge disagreed, concluding that the prosecutor's rebuttal argument contained new material. The difference between the majority and the dissent in this case really comes down to a difference in the interpretation of the prosecutor's rebuttal. And this is exactly the type of deep-in-the-weeds decision that is best left to the discretion of the trial court, which is essentially what the majority did by affirming the district court's decision. Don't expect an en-banc or Supreme Court review of this one. Next, we have a case involving statute of limitations. A plaintiff with potential claims may not simply sit on those claims indefinitely without filing suit. At some point, an applicable statute of limitations may run, or the equitable defense of laches may apply. Now, a key question under a statute of limitation is the determination of when the clock begins to run. The traditional rule has been that a statute of limitation begins to run when a cause of action accrues. Accrual generally occurred when all of the facts existed which established the elements of the cause of action. But under this definition, a claim may have accrued even before the plaintiff is aware that he or she has a claim. And the limitation clock could start running before the plaintiff knew he or she had a claim. Well, to avoid the potential unfairness of having a limitation period run before the plaintiff even knew there was a claim, courts have grafted onto statutes of limitation a so-called discovery rule, pursuant to which a limitation period begins to run only when the plaintiff knows or has some reason to know of the possible claim. Courts have done this on a cause of action by cause of action basis instead of just adopting one general rule. So, in Aloe Vera of America v. United States, the Ninth Circuit held that the discovery rule applied to a claim against the United States for wrongful disclosure of a tax return pursuant to Section 7431 of Title 26. A narrow holding, admittedly, but an important one, and more signs that the courts will apply the discovery rule to virtually any type of statute of limitation. Now we turn to an insurance bad faith case. Insurance companies are frequently accused of being essentially dishonest and of denying claims by insurers in bad faith. But these generalized allegations are insufficient to keep a case alive when the insurance company has strong evidence that the insurance company's denial of a claim is justified. That is what happened in Hojat versus State Farm Mutual, where the plaintiff filed an insurance bad faith claim against State Farm arising out of State Farm's denial of a claim for damages to the plaintiff's car. The problem for the plaintiff was that State Farm had strong documented evidence that the plaintiff had made numerous materially false statements in connection with the insurance claim. And that was the basis for State Farm's motion for summary judgment. State Farm met its initial burden of showing that the denial was justified under the terms of the policy. And the insured did not really present a genuine argument that State Farm had not met its initial burden. Instead, the insured simply argued that summary judgment was not warranted because, they alleged, State Farm manipulated facts, hired dishonest investigators, and relied on unreasonable legal advice to deny their claim. But the plaintiffs failed to provide any facts, much less citations to evidence in the record, to support those sweeping allegations of wrongdoing. And as a result, the plaintiffs failed to satisfy their burden of raising a triable issue of material fact as to their claims or as to State Farm's defenses. You can't defend a properly supported motion for summary judgment just by waving your arms in the air and throwing out unsupported allegations of wrongdoing. You got to do better than that. And that's it for today's Kelso Report. Have a great day in the law.